We are going to start with
Nagorka.
Yeah, I want to make sure that sometimes they get out of order, but Sheila Nagorka versus Nicholas Nagorka. It's case numbers 17CA011221 and 17CA011222. Each party will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal, of course. The court has read the briefs and we are ready to proceed. I remind you that they are recorded, these proceedings, so please keep your voice up and try to stay at the monitor. With that, if you're ready to proceed, we are as well.
I'd like to reserve 5 minutes for rebuttal.
5 minutes?
Yes.
Sure.
And thank you, Your Honor. May it please the court, my name is Stephen Hanadel. I represent the appellant Sheila Nagorka. She's the appellant in both cases. There's a CPO case where it's where Nicholas obtained a CPO against Sheila, and then there's a CPO case where Sheila attempted to obtain a CPO against Nicholas but was denied. I think the trial court got it wrong in both cases. I think this appeal is fairly straightforward in the sense that this is where the trial court got it wrong in its evaluation of the facts. Number one, on the CPO that Nicholas obtained against Sheila, I believe the evidence was insufficient as to support his allegations. On that alone, his CPO should have been denied. In his written petition, he alleged that, and now he filed a petition in August of 17, and on August 14, 2017, and in his written petition, he only spoke of one incident that he said occurred back in May of 17, 3 months earlier. And which I don't think that meets the contemporaneousness requirement of a civil protection order. But then when we got to the full hearing on August 21st or 22nd, 2017, then he says in his testimony, this month she hit me in the face, and so but he had no documentary evidence to back it up with. There's no photographs or. No, he never, when he did call the police on August 14th, 2017, he mentioned nothing, made no allegation that Sheila had struck him, so there's just nothing to back that up with. And so, I submit to this court, there has to be sufficient evidence of serious physical harm.
What about the other witness that testified?
What's that?
The other witness that testified?
His cousin that he's very close to.
Well, that is other evidence, right?
It's evidence, but I don't think it's sufficient evidence. Not in a case like this where it's easy for parties to get when dealing with civil protection orders and the sensitivity and the emotional sensitivity of it. I think there needs to be some corroborative evidence because when emotions are flying high in relationships, there's a lot of conflict and tensions. People are going to say things about each other, and for matters that the court is going to believe, there's got to be some corroborative evidence supporting the allegations, because in these types of domestic situations, the parties will oftentimes just say anything to get at one another, and usually domestic courts should know that and require some sort of corroborative evidence that if somebody says, oh, he hit me or tried to hit me, that there's if Sheila did in fact strike Nicholas and did in fact cause serious physical harm, there should be some bruising that would not just last one day, but maybe for a couple days. Somebody would take a picture.
Well, counsel, to that point, first of all, I guess I would reiterate what Judge Carr said. Isn't the cousin corroborative evidence? But I want to move past that for a minute. Is serious physical harm the standard here? Is that what necessitated for proof?
The evidence has to prove that she caused or attempted to cause serious physical harm, and he's alleging that she struck him in the face. And if there's serious physical harm, there has to be some kind of disfigurement. And there's physical harm and there's serious physical harm. And the statute, the revised code does get into the difference. But serious physical harm requires some sort of permanent disfigurement, temporary serious disfigurement, substantial suffering, prolonged or intractable pain. That wasn't presented here. And so, at best, Nicholas's allegations arise to physical harm, but not serious physical harm. That's just the sufficiency aspect of it. I've also argued that the allegations of his petition and testimony that granting him the CPO was against the manifest way of the evidence. for basically the same reasons. And
So if there was evidence that she attempted to cause or recklessly caused bodily injury, is that sufficient?
I would say in this case, no, because there's, again, based on, first of all, you know, and if this is a manifest weight issue, then so be it, but I would say it's sufficiency issue. But first of all, he mention nothing in the petition, the written petition that initiated the case. He mentioned nothing about her hitting him in the face. He only comes up with that during the trial, during the hearing testimony, and there's no, other than bringing in his cousin that he's very close to corroborate, to kind of be each other's alibis, then, you know, there's no other objective documentary evidence to corroborate that, and not even a picture. Even when he talked to the police the week before, he mentioned nothing about it. So if that takes it into a credibility realm, then the second assignment of error covers that with manifest weight. But I would argue that this is a sufficiency issue, because at the end of the day, you know, domestic courts, they get CPO petitions all the time. People are upset, and oftentimes CPO petitions are filed out of the motions, and so the domestic court has to have some standard somewhere to weed out the claims that that they can't verify, and only consider the ones that can be verified or corroborated, because of the emotional nature of these type of proceedings.
But just to make it clear, your corroboration would require some type of physical evidence.
At least some kind of documentary evidence. Whether if it's like, if he would have said something to the police the week before, he talked to the police the week before, if he would have said something to the officer there, or if there was a picture or something. I mean, it doesn't always have to be physical evidence, but some kind of objective corroborative evidence that would show that, okay, yeah, he's got a bruise on his face or something like that, and there's nothing at all.
Wouldn't that standard go throughout most CPOs?
What's that?
Wouldn't that standard throughout most CPOs that we see in courts?
Well,
People don't usually strike people in front of other people. People don't usually, have witnesses for all this. And like you said, it's within the home usually.
well, I think that with CPO, it calls for the standard. I think is serious physical harm.
Well, that's one part of the statute.
It's one part, but even if it's, but I think for any incident to be serious enough to warrant a civil protection order, I think the harm has got to be somewhat, if the person is in fact struck, that there's got to be some visible, whether if it's a red mark or something, because like even if somebody gets slapped in the face, it's going to cause a red mark on the skin, if it's not a bruise. So there's got to be just some kind of corroborative evidence. And so, and especially then in this case, the only person corroborating him is a cousin that he's close to, when there could have been other corroborative evidence based on the testimony he provided. If he's saying he got struck in the face, well, then there at least would be some visible marks on his face of some sort that they could have taken a picture of. And also the fact that he did talk to the police allegedly after this happened, in which he said nothing to the police. So I think that's in this particular case, I think this gives rise to a sufficiency issue. If it doesn't, then it's definitely a manifest weight issue, because I don't think his allegations can in any way be credible, because he did not mention it in his written petition. He mentioned nothing to the police officer. There's no pictures or any kind of corroborative evidence, no documentary evidence to back up what he's saying. And meanwhile, while we're on the credibility issue, the trial court just completely dismissed all of what Sheila had to say, despite the fact that she presented 5 exhibits in the hearing that include text messages with her son, when she barricaded herself in the truck, with the hacksaw blade, and locked the doors, fearing for her safety. And yet the magistrate just completely disregarded all of that, because 3 months earlier she apparently had made an untruthful statement to the Medina County Sheriff, and over an immaterial fact, over a fact that had nothing to do with the August incidents. And And yet, and you see in the transcript where the magistrate mistook that as lying to a court and perjuring herself, and yet that was not the case at all. What happened was that
But counsel, you're appealing the judge's order, correct?
ultimately, and I know the judge didn't make
corrected that.
the judge didn't make the correction, but I still think it was and I do note that in the brief, but I still think it was wrong of the judge to just use that statement to the police to disregard everything else she says. I don't. In Evidence Rule 608B gets into when you can use one incident to attack someone's character and to impeach them, and in order to do that, what the rule says is that particular incident has to be clearly probative of truthfulness, and I don't think that's the case here. Is that under 608B, her giving an untruthful statement to the police over a completely unrelated incident 3 months earlier is not clearly probative of whether she's telling the truth now about whether her husband was trying to hurt her.
You're at 5 minutes.
Okay, I will reserve for about. Thank you.
All right, thank you.
Good morning. Police Court, my name is James Smith. I represent Mr. Nagorka. With regards to the one that was granted, I believe the questions that the court asked were proper, and I think I know where the court's standing on that. So rather than just babble on my opinion, I would just ask the court if you have any questions to me with regarding to that.
I don't want you to assume anything about how we stand.
Okay, fair enough.
Purpose of the record.
Fair enough. There is no need of corroborative evidence. Judge Carr, you correctly stated that would knock out probably almost every domestic violence I ever filed and got granted. Many of these things happen in a closed door. Now, I think counsel is mistaking that domestic violence includes A or B, not A and B. So this idea of it needs to be physical harm, that's not the case. If I take a ball bat and swing it at my wife, miss and hit the lamp, and somebody witnesses that, I attempted to cause harm to her. Whether I hit her or not, that would fall under A. On the other hand, if I pull my wife over in the corner and I say, hey, you listen here, you do this, or I'm going to shoot you tonight, that's enough. Even though there's no harm, there's no mark. Neither one of those need to be cooperative. You come in, you tell your story. Number one thing, credibility. Who do we believe? Who do we not believe? So we can talk about all the things that he didn't do, and that's a lot of things. There's cases of battered women who were beat for 5 years and never told anybody, never made a report to the police. So it doesn't matter that he didn't tell the police this, he didn't tell the police that. What matters is you're in court, what did you say? The trier of fact, they look at you, they look at what you're saying, not only what you say, your gesture, your manners, what are you doing? They either believe you or they don't believe you. If they choose to believe you, in this case, they did choose to believe Mr. Nagorka in his testimony that he was hit in the face. They chose to believe his corroborative evidence, and they believe that that fell under A, that was bodily injury. They issued it. I think that's clear and shut. As regards to the denial of the petition by Mrs. Nagorka, I would agree that the judge definitely straightened that out. She had submitted an affidavit. She said she lied to the police about the incident that actually had to do with 3 months earlier. And that, coupled with her demeanor and everything else, the court just did not find that she had any credibility. So no matter what she said, they didn't find that that had any credibility in it. So they chose to deny her petition, and I think correctfully so. That's the job of the trial court. It's not just, how much evidence did I bring in here and I can stack up on a shelf and show it all to you. It has to be credible. Who determines that? The trial court. Quite simply, they determined her evidence was not credible, and they denied her petition.
Counsel, as to the slap in the face incident, was the magistrate and then the judge permitted to consider it since it wasn't a part of the petition?
I think they certainly are. I'm aware of no rule that says they are not, and if I am mistaken and there is some rule, I think that counsel would have had to object to that, just like evidence that maybe gets in and, well, you have to object and you have to save the record and say, wait, I object to that. Once the door's open, you let it continue to go, who knows what we're going to hear? So there was no objection to that to say, wait a minute, they're going outside the scope of what we're hearing here today. But I don't believe there is such a rule. These things, people go in, they fill out a paper petition by themselves and they file it. you know, we always, sometimes they'll even hear, I've sat in where all of a sudden the judge takes over for everybody. He starts saying, do you believe that was serious physical harm committed on you? Or were you threatened? Were you afraid of your life? I mean, that's not in the petition. The judge is trying to bear that out. If quite simply we were just going to look at the petition and rule on that, there'd be no need for a hearing. We just summarily look at it and go, well, it meets it or it doesn't meet it.
Except that there's no notice to the other side, right?
I think the notice to the other side has to do with, there's an allegation of domestic violence.
And you don't know what, I mean, they could come in with 50 different things, then, according to your theory, and then you don't have, how do you defend against that?
Okay, they could, but the law is clear on that. I can't start talking about incidents 3 years ago and use that for today, but I can use it for the pattern, to show that there is a pattern of conduct. In other words, threatening activity, and now it escalates. So while that wouldn't be relevant, I believe that the incident 3 months earlier, if it was just that incident alone, even if she came in and said, yeah, you bet I did that, I don't think it would be relevant, because if he was in fear of it, he would have had to file 3 months earlier. I think it's the later incidents that the judge has ruled on. So you could come in and make up all kinds of things. Quite simply, when I get a client come in, I say, what happened in the last 2 weeks? Tell me. I need to know, because I need to be prepared for anything that's going to come up in that open and shut case. So no, I believe the file that when you file domestic violence, you're on notice that it could be anything within the 2 to 3 weeks prior to that filing of that. So I think learned lawyers would know that anything can come up. And again, there was no objection to it, and I'm not aware of any rule out there that says you cannot go outside of the scope of the original petition.
Well, I think Judge Carr was suggesting it'd be a due process violation. You know, because there's no opportunity no notice, which...
Well, not to belabor, but I believe the notice is domestic violence was committed. That I believe is all that...
Well, but counsel, theoretically, domestic violence can be committed in many different ways on many different occasions.
Right.
Hypothetically, as to the slapping incident, and I respect the fact that I expect I'm going to look at the record and not see an objection, but past that, and since we're talking about due process, what if she had 3 witnesses who said that never happened? How would she have even known to be prepared for that?
I suppose she wouldn't in that case, but this is not a criminal case, Your Honor. So I think the standard of due process would be slightly different. You know, a criminal allegation, you got to cite with specificity, hey, here's the day, here's the time, here's the incident. This is not a criminal case. I think therein lies the major difference. Thank you.
Any other questions? All right, thank you for your presentation. I've got you at 4:42 for the
That should be enough. About the point about Mr. Nagorka not alleging the slap in the face incident in his written petition, I do recall bringing that up to the magistrate in my argument to dismiss his CPO petition. I don't specifically recall whether if I said the word objection or not, but it is in the transcript, especially in closing argument. I did make the point to the magistrate that that Mr. Nagorka did not raise the alleged August incident in his written petition, and therefore should not have been considered, or at least been denied on that basis. So I can't recall specifically what I said, but I do know that I brought that up. So in some capacity. And as far as getting back to credibility, as far as my client's concerned, I mean, the magistrate made very clear in his decision, which substantively the judge upheld, that he looked at the one incident of telling one untruthful statement to the police 3 months earlier about when she drove the car into the ditch, about whether her husband was with her or not, and use that one item to blanketly just discredit her on everything she says. And I just don't think that is not what Evidence Rule 608B calls for. I think he greatly misconstrued, greatly misapplied that rule you certainly can use an incident of untruthfulness to impeach someone's character or credibility if that is clearly probative. And clearly probative would mean, how does that relate to the case at hand? And so when Mrs. Nagorka is telling about how her husband is acting crazy and threatening her physical safety to the point where she's got to barricade herself in the truck, and she's got text messages with her son in real time that's showing that while that's all going on, which which corroborates what she's saying, and the text messages with her husband about expressing concern how he's staying up all night for several nights in a row, and it's affecting his behavior, and therefore, which is causing her great concern. She presented all those items to the court. I mean, those were not things that were just made up or in any way contrived or forged. And yet the trial court, the magistrate, and the judge, they just disregarded all that because, 3 months earlier she made one untruthful statement to the police about whether her husband was with her in the car when she drove in the ditch. And so I think that it's a complete misapplication of 608B. Certainly that as far as, and Mrs. Nagorka explained herself about why, and she explained the circumstances, because it was only because Nicholas had first told the police that he wasn't with her, and she didn't know quite what to say at that point, and that's when her attorney on that case advised her that it was a non-material fact, and so therefore not to risk upsetting her husband or just the whole situation, told the police that she wasn't with her, because ultimately she was charged with OVI, which later was dismissed in a diversion program in Medina Municipal Court. So at the end of the day, that one item does not warrant discrediting her on all of her allegations, especially on allegations where she's got corroborative documentary evidence to support. And so it can certainly warrant an inquiry, but discrediting her on everything just went way too far. So I would ask the court to reverse the granting of the civil protection order in favor of Mr. Nagorka and reverse the denial of Mrs. Nagorka's CPO petition.
All right, thank you both for your presentations today. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail each of you a copy of the court's decision on the day it is released, and the opinions are also posted on the Supreme Court's website, so feel free to check the Supreme Court's website as well. Thank you again for your